So now, our next speaker, kung kanina, no, about requirements, about food labeling, now our speaker will walk us through the international property rights naman of MSMEs to maintain a competitive edge. Oh, yung itong mga webinars na ito, tinutulungan tayo na even to expand pa, give best quality when we are in an international scene. Ayan. So for our next speaker, please welcome the Information Officer and Assistant Division Chief in the Information Dissemination and Training Division, or IDTD, Documentation, Information and Technology Transfer Bureau, DITTB of the Intellectual Property Office, Ms. Emmelina Masanque.
Good afternoon to all our participants, to our MSMEs. Magandang hapon po sa inyong lahat. Kami po sa Intellectual Property Office of the Philippines or IPOPHIL ay lubos na nagagalak na makasama namin kayo ngayong hapon na ito at makapagbahagi po kami ng kaunting kaalaman tungkol sa intellectual property. I am Ms. Emmelina Masanque, Assistant Division Chief of the Documentation, Information and Technology Transfer Bureau of the IPOPHIL. Let me start by introducing you to the Intellectual Property Office of the Philippines. We will also have a brief discussion of the intellectual property system in the country, the different intellectual property rights and their importance, and the assistance that IPOPHIL has for our MSMEs, our inventors, researchers, artists, and the general public. Allow me now to share my screen. Our topic for this afternoon is entitled Protect Your Intellectual Property to Gain Competitive Edge. So I hope that by the end of this session, you will be able to learn how to protect your intellectual property so that you'll be able to earn from them and gain competitive edge in the market. So let us begin. The Philippine Constitution states that the state or government is responsible for protecting the intellectual property of its citizens. Republic Act 8293, or the Intellectual Property Code of the Philippines, was enacted to protect and secure the exclusive rights of our scientists, our inventors, our artists, and other gifted citizens as it modernized the IP system of the country. Nasa Constitution po ng Pilipinas ang mandato na ito. Ano nga ba ang nilalaman ng IP Code ng Pilipinas? Ayon sa IP Code, kinikilala ng ating Estado ang pagkakaroon ng mabisang batas na mangangalaga sa intellectual property at industrial property system sa ating bansa na makakatulong sa pag-unlad ng ating lokal at malikhaing gawain. Pangasiwaan ang technology transfer, makapaghikayat ng foreign investments, at magkaroon ng tiyak na market access sa ating mga produkto. The IP Code enumerates several types of IP to which creative or innovative works can be classified under and can be protected. These are copyright and related rights, trademarks and service marks, geographic indications, industrial designs, patents, layout designs or topographies of integrated circuits, and protection of undisclosed information. At dahil nga po sa IP Code na itatag ang aming tanggapan ang Intellectual Property Office of the Philippines noong 1998. So ano nga ba ang intellectual property? Alam niyo ba that we are surrounded by IP? IP is part of our everyday lives, from the first thing that we do in the morning until the last thing that we do before we fall asleep. So ano nga ba to? Everything we consume has an IP. Mula sa tinitimpla mong kape sa umaga, sa damit at sapatos na susuotin mo sa office or school, ang brand at model ng sasakyan mo, ang feature ng cellphone na gamit mo, hanggang sa ginagamit mong toothpaste at toothbrush ay may mga intellectual properties. Every product or service that we use in our daily lives is the result of a long chain of big or small innovation, such as new design or improvement that make a product look or function better. We can easily find IP in almost every product. Intellectual property is the creation or the product of the human mind. It may come in the form of an invention, a name, an image, a symbol, or a design, or even a literary or artistic work. We make use of intellectual property in its many forms. An IP is an asset. Maari mo itong pagkakitaan kung alam mo kung paano ito pangalagaan at bigyan ng proteksyon. So paano nga ba? The first step is to identify your IP. Sa anong kategorya mapapabilang ang iyong IP? Okay, the IP code enumerates several types of IP to which creative or innovative works can be classified. So, isa-isahin po natin sila. So, first, we have copyright. Copyright is the rights of creators or authors over their literary, scientific, and artistic works. While trademark is any visible sign that distinguishes the good or services offered or provided by any business from those produced by others in the market. Then we have patent. It is a grant issued by the government for an invention. An invention may be a product or a process. It must be new, should involve an inventive step, and must be industrially applicable for an invention to become a patent. What else? We also have utility model. It's a technical or functional improvement of an existing product or technology. It must be new and industrially applicable. Industrial design is a distinctive and aesthetic design of your product. Layout design or topography of integrated circuits. Layout design of an integrated circuit is the three-dimensional disposition prepared for an integrated circuit intended for manufacture. Kung alam niyo po ang laptop niyo and then yung computer niyo, these are working, nagagamit niyo sila because of this layout design or topography of integrated circuits. Then, lastly, we have trade secret or undisclosed information. This is confidential or secret information that has commercial value. It may be a formulation or a proportion of the contents or ingredients or a know-how of a business. A trade secret has no formal registration procedure required. Perfect example for this trade secret is the Coca-Cola formulation. We see in the bottle the ingredients, but we don't know exactly the actual proportion of the water, the sugar, and all these. Okay, so that is trade secret of Coca-Cola. So why do we have to register our intellectual properties or intellectual property assets? It is essential to register your intellectual property because these are your valuable assets. Thus, they need to be protected. Knowing your IPRs and protecting them can be your business competitive edge. Your IP rights give you the exclusive right to use, enjoy, and earn from your creations. For this afternoon, I will share with you a bit more of the most popular intellectual property rights. What are these? We have copyright, trademark, patent, utility model, and industrial design. So first we have copyright. Okay. For us to easily recall each type, I will share with you some keywords that will help you. When we say copyright, we refer to literary and artistic works or creations. What is copyright? The legal protection extended to the owner of the rights in an original work that one has created. Remember, copyright protects the creative work or artistic creation of the person. How is copyright acquired? Works are protected by the sole fact of their creation, irrespective of the mode or form of expression, as well as their content, quality, or purpose. Protection is automatic from its moment of creation. From the moment of creation, the author already or artist already gets protection. However, it is best to deposit a copyright of his work to complete the records of the National Library. At the same time, it can also serve as a legal basis na ikaw ang lumikha or ang may likha nito at para na rin may protection ka once you commercialize your work. An idea in your head is not yet protected by IP law. You cannot simply say that this idea is yours, that it already has legal protection or ownership by you. It doesn't work like that. It says here, only the expression of an idea is protected by copyright, not the idea itself. It will only have a legal protection if this idea in your head is expressed in a creative or artistic form. Halimbawa, may nabuo kang kanta sa isip mo. Hanggat hindi yan na-express into lyrics or song, then hindi pa yan protected. So what are the rights of a copyright owner? If you are a copyright owner, you get two rights. What are these? Economic rights and moral rights. Okay? Economic right is to derive financial reward from the use of your work by others. Ito yung pagkakakitaan ng author or artist. Okay? Whereas, moral rights, ito yung right of attribution na kapag ginamit ng kahit sino yung gawa ng author or artist, dapat ma-recognize na siya ang author or artist or ang may gawa. Ngayon, dumako naman tayo sa pinakakilala sa lahat ng intellectual property. Ano nga iyon? Ito ay ang trademark. Kapag narinig nyo ang branding or logo, yan ay nagre-refer sa trademark. So, keyword natin sa trademark is branding. Here are sample logos that you can identify with. Sige nga, tignan natin kung kakilala nyo ang mga symbols or logos na ito. Yan. I'm sure marami sa inyo ang nakahula or nakaalala kung ano-ano ang mga ito, ano-ano ang mga images na to. Bakit kaya madali natin silang natandaan or nahulaan? Kasi yan ang ginagawa ng trademarks. Aalamin natin sa mga susunod na slides. The IP code defines trademark as any visible sign distinguishing the goods or services of an enterprise. In simple terms, it is the name or symbol or a combination of both that you put on your product or service. Again, you have your logos, brand names, taglines, even mascots. Anything that you use for branding may be considered as trademark. So what does a trademark do? Trademark protection ensures that the owner has an exclusive right to use, sell, or license and profit from his trademark. The protection for a trademark lasts for 10 years from registration and may be renewed as long as the trademark is being used and as long as the trademark is maintained. So you see on the bottom of your screen examples of trademark. Okay. We can classify a trademark according to their composition. So ano-ano tong mga types of mark according to composition? Okay. So it can be just a word such as Nike. Pwede ring symbol siya such as the swoosh mark, or a phrase, just do it, or a combination of both the word and symbol, just like this Nike and the swoosh. Okay. Ano pa? According to composition, pwede rin three-dimensional figure or a stamped container. In creating a mark, you should also consider the strength of a mark. A strong mark, sabi nila, is easier to register. So what are these? So we have types of mark according to strength. Okay? The strongest type of mark is what we call fanciful or coined. Okay. Coined kasi made up words lang siya. For example, is Kodak. Kodak has really no meaning. Alam na lang natin siya ngayon kasi it has been very popular. Okay? Pero, it's just a made up word. Okay? Or coined. Okay? Pwede rin, pagsamahin nyo yung first two letters ng pangalan ng mga anak nyo and you come up with a word, a coined word, which you can use as your trademark. So sabi sa libro, ang pinaka or ang strongest mark that can be registered, easily registered, is what you call fanciful or coined. Ano yung susunod sa fanciful or coined? Arbitrary. An arbitrary mark is a word or image unrelated to goods or services. So you see there the example of Apple. Why is it an example of an arbitrary mark? Kasi easily malaman mo na ang apple, ang ma-identify mo siya that it's a fruit, di ba? Mansanas. Pero in this case, it is an example of an arbitrary mark because we know very well that Apple here is a mark for electronics, di ba? Or for computer, or cell phone, mobile phone, laptop, yun. Okay? It's a word or image unrelated to goods or services. Yan ang arbitrary. So, strong mark pa din siya. It can be easily registered. Okay? So, what's next? Suggestive. Okay? Ano naman ang suggestive? It requires consumers to connect product with mark. Okay? Example of that is flawless. When you come out with a flawless clinic, ano sa tingin nyo ang nangyari sa inyo? Or mangyari sa balat nyo? Then you become, yun nga sabi natin, flawless skin. Your skin is unblemished. So yun. It's suggestive kasi it requires consumers to connect product with the mark. By flawless or the flawless clinic or yung services ng flawless, then you already know what it is or what service or what product it has. So yun ang suggestive. Okay? The fourth one or the fourth type is what we call descriptive. This merely describes the goods or services like cold and creamy. If you have this mark as cold and creamy, ano kaya ang iyong product? Oo, it may be that your product is ice cream and it merely describes your goods or product, which is ice cream. Then, it may not be registered kasi it just describes the goods or services. It's not something very unique. Okay. And lastly, generic. This is a name or product that seeks to identify, that they seek to identify. Parehas lang. Kung ano yung produkto mo, yun yung ginamit mong marka, then it cannot be registered. It is generic. Okay? Just like in our example, ice cream. Okay? Ice cream ang brand mo or trademark na ginamit mo, and then your product is ice cream itself. Therefore, that is generic and cannot be registered. Okay? Besides that, knowing that we have types of mark according to strength, okay, we also have functions of a mark. A trademark actually guides a consumer in deciding what to buy because it serves various functions. Okay? A trademark can be a source identifier. Kapag nakita mo ang 3 stripes na yan, alam mo kung anong brand ng rubber shoes yan. Or kapag nakita mo naman itong swoosh, swoosh mark, alam mo kung saan yan mabibili. Okay? A trademark is also a differentiator. Madali mo ma-distinguish ang produkto na lagi mong gamit or tinatangkilik. Next, it's a quality indicator. Along with the name, dala-dala din ito ang magandang uri ng isang produkto or magandang serbisyo ng isang service mark or trademark. Okay? Nababalik-balikan ng mamimili or consumers. Okay? Ito yung quality ng isang produkto. Okay? So very important is the quality of your product. Along with your mark, it's the quality that is also very important that you should have. Okay? And lastly, it is an advertising device. Kanina, yung mga examples na pinakita natin na hinulaan nyo, madali nyo silang nahulaan kasi madalas ginagamit sila sa commercial. Okay? Ginagamit sila as an advertising device. Ngayon, meron din tayong mga sinasabi na mga marks na hindi pwedeng iparehistro. Ano-ano itong mga to? Okay, these are non-registrable marks. Okay, those that are immoral, deceptive, scandalous, or that can disparage cannot be registered. For example, using the facade of Malacanang sa isang alcoholic beverage. So hindi yan papasa sa examiner, then it will not be registered. Okay, even flags, coats of arms, or other emblems cannot be registered as trademark. Names, portraits, or signatures identifying a particular individual. Okay, you cannot register the portrait of Piolo Pascual if you are not him or without his consent, or use the signature of Manny Pacquiao if you are not Manny Pacquiao. Names, portraits, or signatures of a deceased president of the Philippines cannot be registered, like the signature of the former President Marcos, unless with the consent of his spouse, Mrs. Imelda Marcos. Okay? So ano pa yung mga non-registrable marks na kino-consider natin? Those that are misleading, like having a brand, Apple, but your products are oranges. Okay? Generic mark cannot be registered, like using makina for engines. Okay? Also descriptive, sinabi natin kanina, like matamis for ripe mangoes, unless the term or terms acquired distinctiveness or secondary meaning, wherein consumer recognition as a brand name rather than as a merely descriptive term, such as sharp. Okay? Sharp here, of course, we know the meaning of sharp, matulis, ganyan, diba? But sharp here is a mark for appliance, okay? Appliance. And then, those that are customary to trade cannot be registered as trademark. Ano yung example natin dyan? Yan. When we see this white, blue, or blue, white, red na pole, then we know that there is a barber shop nearby. So yan, cannot be registered. Okay? Ano pa? Those that are identical or confusingly similar with an internationally well-known mark. Okay? Like that of Rolex is an internationally well-known mark for watches, and using the same mark for a musical lounge or music lounge cannot be registered. Also, those that are contrary to public order and morality cannot be registered. Okay. So sabihin nyo, what is it for me? Bakit kailangan kong iparegister ang aking trademark? Okay. Because these are the importance of trademark. A trademark owner gets these 3 G's. Ano ba to? First, grants exclusivity. Only the trademark owner has the right to use, sell, license his trademark. Therefore, only the trademark owner has the right to earn from his trademark. Okay. Also, gains recognition and reputation. Along with your trademark, as mentioned a while ago, comes the good quality that you should produce with your product or your service. Consumers will recall and remember the product or the trademark once they have experienced the good quality in a product or service. They will keep on patronizing your product, and of course, that generates goodwill. How? They will share the good experience that they have with your product or service mark with their families and friends. Okay? So, always remember that once you have your trademark protection, then you get this 3 Gs, grants exclusivity, you can gain recognition and reputation by the good quality that you have for your products or your service, and you can generate goodwill, or the trademark can generate goodwill. Okay. Okay, trademark success story. This is a very good example of a success story. We know very well that Jollibee Foods Corporation bought Mang Inasal. How much? Okay, Jollibee acquired Mang Inasal Philippines Incorporated for 3 billion from Injap Investments Incorporated. Okay, so 2 billion, yung 2 billion itself is for IP-related assets. And I'm sure a lot of you know the story of Mang Inasal. Okay. So tayo as MSMEs, we should take the risk. If we know that we want this business to grow, then take the risk, take the first step. Lahat naman ay nagsisimula sa maliit. Then later on, with your hard work and yun nga, with protecting your IPs, then you can get bigger or you can grow big, just like Mang Inasal. Okay. It's also important to know the difference between trademark and business name. Okay, so it should not be, a trademark should not be confused with business name. Ano ba yung kaibahan nila? Yan. Of course, a trademark is registered with IPOFIL, whereas business name is registered with DTI kapag sole proprietor. Kapag naman corporation, then it's with SEC. With your trademark, the owner gets exclusive right over the use of the mark. Okay. A trademark is used as an identifier of a product or service. And of course, your registration of trademark is voluntary. But of course, the IPOFIL highly encourage you to register your trademark, although it is voluntary, para sa dulo hindi kayo magsisi na magaya kayo ng iba. Okay? So protection is the key para hindi kayo magaya ng iba. Whereas business name, its registration is required for the owner to have a legal identity. And saan nga ba ginagamit ang business name? It is used in business transactions other than the true name of persons and or juridical entities. A business name registration merely provides the business a legal identity in order to actually operate the business. Okay? For you to operate your business, you need a business and mayor's permit. Okay? So, yan ang kaibahan ng trademark at ng business name. So, hindi mo sasabihin na, anyway, I already have a business name. I don't need a trademark. No. Hindi pwede yon kasi magkaiba ang function ng trademark at ng business name. Okay. So, how do you file your trademark? Sabi ko kanina, in this pandemic, we highly encourage online filing. But just the same, ito yung mga kailangan natin, no? Okay. Now, we move on to the next. Kung ang trademark ay ang pangalan or logo or tagline ng produkto, dumako naman tayo ngayon sa isa pang uri ng IP. Ito naman ay ang produkto mismo. Okay, if it's the product itself that you want to have protection of, then yun yung patent, and later on, yung susunod pa, utility model at industrial design. Okay? So, ang keyword natin sa patent is invention. Okay? By invention, we refer to new product or new process that solves technical problem. Okay? Okay, the inventor, of course, is the person who makes inventions. Okay, and yung protection is the right to a patent. So once you have your invention, you can file for a patent protection if it would meet the requirements. Ano ba yung mga requirements na yon? But before that, ito muna. Okay, so for you to understand well what patent is, okay, sabi natin kanina, a patent solves a problem, a technical problem. So it improves lives through health-related inventions or ubiquitous technologies. It can save lives, health and safety products. It makes tasks easier, okay? Because of the transportation that we have or the form of communication that we have now that have been invented, then patent makes tasks easier. Of course, patent entertains us. How? Yan, yung mga gadgets natin na meron iba-ibang mga games, ganyan. Or the form of communication or entertainment, yung songs na nakikita natin sa ating iPad. Yon. Or not the songs, but the invention of, for example, the iPad, ganyan. Or ng TV, television, or ng computer, or yon. So yun ang patent. For example, you have a hair loss problem. Ano ang solution or invention na pwede mong magawa? New formulation to prevent hair loss. Okay? Bag gets damaged easily. New or improved material for bags. Ito, process or method naman. Yung sa hair loss, yung formulation to prevent hair loss can be chemical formulation or process or method of preparation. If home security is at stake, you have new or improved locking system, AI-assisted digital door locks. Alternative to gasoline cars, okay, high price of gasoline or air pollution and even air pollution, there is the new electric car. Yun. So yun naman ay system and mechanism. Yun yung mga invention doon. Short shelf life of bread. Then there's this healthy additive to make bread shelf life longer, okay? To make our food tasty, etc. There's a method or process of cooking, okay? Pero ito are mostly utility models, which can be discussed later, okay? So these are examples of solutions to technical problems, and yun ang ginagawa ng patent, okay? So ano nga ba ang patent? It is an exclusive right granted to an inventor by the government for a limited period in return for sufficiently disclosing the invention for the purpose of technological advancement. Okay? Exclusive right siya kasi nga nabanggit ko kanina na ang patent owner lang ang maaring gumamit, makapagbenta, at kumita sa kanyang invention. Siya lang ang makikinabang sa kanyang produkto. Ang nagagrant ng patent or naggagrant ng patent ay ang government, which is our office, the Intellectual Property Office of the Philippines. For a limited period, kasi, ano yung limited period for a patent? It is 20 years from filing date of the patent. After that, wala nang protection ang patent and it becomes a public domain, kung saan pwede na siyang gamitin ng iba at maaari din mapagmulan ng iba pang innovation or improvement ng mga ibang tao. Okay? Dito umiikot at nagpapatuloy ang innovation or technological development. Okay. Para ma-consider natin or ng patent office na patentable ang isang invention, meron itong 3 requirements na dapat ipasa. Ano yon? Okay. The invention must be new. It must have inventive step and must be industrially applicable. Kailan bago? Kailangan bago ang iyong invention, okay? Wala pa sa buong mundo ang nakapaglabas nitong produkto. Wala pa lumabas sa merkado o wala kahit nasusulat or na-publish na ganitong produkto, okay? Then, it is new, okay? Yung inventive step naman, ito ang actually pinakamahirap na test dyan sa patent. Ito ang ultimate test para mag-grant ka ng patent. Yun yung inventive step. Ano ba yun? Okay? Ang ultimate test ng isang invention, kung mag-grant ito ng patent, ano ang inventive step? Ito yung kahit na isang eksperto na sa field na iyon, hindi pa maisip na pwede pala itong gawin. Magagawa pala ito. Okay? Yun yung tinatawag na non-obviousness. Itong inventive step is the non-obviousness. And lastly, it must be industrially applicable. Mama-manufacture ba ito? Aandar ba ito? Magagamit ba ito? Gagana ba ito? Yun yung industrial applicability. Okay? So, 3 requirements for patentability. First, the invention must be new, it must have inventive step, and must be industrially applicable. Okay? Okay? So, as mentioned, online filing is highly recommended. Okay, this is the common mistake that we get in the office, no? Yun, darating ang client, sasabihin niya, how do I patent my trademark? Tama ba ito? Okay. So, based on our discussion, kung kayo nakikinig ng maigi, masasabi nyo na hindi siya tama. Kaya nga siya, it's a common mistake. It's a mistake. Bakit? Okay? Simple distinction lang that when we say patent, we refer to the product or the process itself. Now, the name or symbol or logo you put on your product is what you call trademark. Okay, so these are 2 different IP rights. Okay, I hope it is clear, no? Okay, now we move on. Okay. Ito yung utility model. Sa ibang bansa, ang tawag dito ay petty patents. Bakit siya petty patents? Kasi improvement siya or innovation siya. May pinanggalingan. May pinanggalingan na siya. And it is a petty patent kasi okay, protection for innovations that are novel and industrially applicable, that are new and industrially applicable but lack an inventive step. Okay. Kaya siya tawag na petty patents kasi nawawala yung pinaka-importante sa patent protection, which is inventive step. Okay. Sa utility model, it's an improvement or innovation, kaya wala na yung inventive step. Importante lang na it has to be novel or new and industrially applicable. Okay. Protection is 7 years and no renewal. So what are the requirements when filing a utility model? So online filing is highly recommended. So 2 copies of the request for the registration of utility model. And then there is also specification. Ito yung laman ng specification. And the filing fee of 1,737 pesos and 20 centavos for small entity. And then 3,636 pesos for big entity. As mentioned, small entity kayo mako-consider if your asset is 100 million below. And big entity kapag more than 100 million below. Okay? So, tatandaan natin na kapag sinabi nating patent at utility model, it is the function ng produkto ang binibigyan natin ng protection. Okay? Ngayon, kung yung itsura naman ang gusto natin mabigyan ng protection, okay? So, sinabi natin na kapag yung pangalan ng produkto, then trademark yon. Kapag yung function niya, then patent. Kung wala naman siyang inventive step, pwede sa utility model if it's an innovation or an improvement. Ngayon, kapag yung itsura niya, yung physical appearance niya, or yung ganda niya, aesthetic design niya, that would fall under another intellectual property, which is industrial design. Okay? Ang keyword natin dyan is aesthetics. It's the appearance. Okay? So, I repeat, patent and utility model, it is the function that you want to be protected. At yung function ng product. Industrial design, it's the aesthetics of the product. Yung appearance ng produkto mismo. Okay? So ano yung dapat tandaan sa industrial design? As mentioned, protection for the aesthetic or ornamental features of a manufactured item without considering its functions. It's the physical appearance, form, shape, contour, ornamental, and aesthetic features. The protection is 5 years and renewable for 2 consecutive periods of 5 years each. Okay? So ano naman ang mga conditions or requirements to obtain industrial design protection? First, it has to be new or original. It has to be an article of manufacture, not dictated by technical or functional considerations. Of course, it should not be contrary to public order or health and morals. Okay? Karamihan sa mga industrial designs ay mga handicrafts and furniture. Okay? So, how do you file your industrial design? So, eto po siya. But we highly recommend online filing. So, punta kayo sa IPOFIL website, www.ipofil.gov.ph, and then nandoon sa online services ang filing online. Yan. Actually, matatapos na tayo or patapos na tayo. Ito lang, I'd like to give you this table which can be of help for you to be able to understand clearly each of the intellectual property rights that I mentioned or that I discussed. No? Now we come to the IPOFIL assistance programs for our MSMEs, our inventors, artists, and the general public. So ano-ano tong mga programa ng IPOFIL na makakatulong sa inyo? First, we have the intellectual property satellite offices. We are accessible nationwide. Ito yung mga cities, key cities na meron tayong satellite office, no? The IPSOs are the IPOFIL's primary marketing arm in the countryside, okay? They assist in the implementation of IPOFIL programs and projects which promote the effective utilization of the IP system in the regions and provinces. They help our MSMEs go about their IP applications, okay? So that's one. Ano pa? We also have the Innovation Technology Support Offices. Okay? This was established to strengthen local institutional capacity to access patent information and make use of the patent system. Okay? We have 100 institutions across the country, pero yung active ones, we have 86 active institutions across the country. Okay? Ano yung services na pwede natin mahingi sa ating Innovation Technology Support Offices? Ito, yung mga ITSOs na to, they are universities, no? In universities. Okay? You can seek assistance in patent drafting, patent search, or patent and TM copyright prosecution. You can visit our website, ipofil.gov.ph, to know more about the Innovation Technology Support Offices, and if there are ITSOs or universities that have ITSOs in your places, no? Okay. Of course, we have our online services, ETM file, E-invention file, EUM file, E-industrial design file, or EID file. Okay. Pag naman subsequent transactions, after you have filed, may mga subsequent transactions like yung responding to examiner's actions. Ito, meron tayong e-doc file for TM. Okay. Then, pwede rin kayo mag-trademark search. We highly recommend that before you file your trademark application, is you were able to undergo trademark search. Importante yan na pag-trademark search kayo. So, you know, before you begin with your trademark application, meron or wala pang nakapag-file or gumagamit ng trademark na yon. Okay? Bago nyo man lang maipasa sa office ang inyong application form, dapat na-search nyo na meron or walang kaparehas. Siyempre, magandang walang kaparehas from the start so that hindi naman masayang ang pagod nyo, ang filing fee na ibabayad nyo sa office kasi hindi na yon babalik sa inyo. Okay? Once na na-file nyo na yan at meron palang kaparehas ang iyong trademark, mabaliwala na yung filing fee nyo. Hindi na maisosoli sa inyo. Okay? So, it is highly recommended that you conduct a trademark search first. Doon din sa website, ipofil.gov.ph. Sa e-services, meron doon trademark search. Okay? Just key in the word that you would want to look for and then press enter and lalabas lahat doon ng related na trademarks pending and registered. Okay? And then, for assistance, meron tayong online customer service. Yan yung tinatawag naming PIPO. Okay? Diyan din sa ipofil.gov.ph. Pagbukas nyo lang ng ipofil.gov.ph, meron na bandang baba sa lower right portion ng computer nyo, nakalagay, how may I assist you? So that effect, parang ganon. Siya si Pipo, then you can type in your concerns or your questions. Okay? And then sasagot po sa inyo yung ang aming customer service na personnel. Okay. We also have other assistance program like the Inventor Assistance Program, that gives free legal advice on patent applications and free basic seminar on patent search and patent drafting. We also have Wanna Make a Mark, Wanna Design, Wanna Invent. Itong mga wanas natin, the basic application fees are waived. Partner namin dito ang Department of Trade and Industry, okay? The Wanna Make a Mark, Wanna Invent, and Wanna Design programs are registration incentive packages that allow eligible MSMEs to have their intellectual property assets registered at a reduced cost. We have partnered with the Department of Trade and Industry in the implementation of these programs. Okay? For the full details of these programs, you may visit our website. And you may also get in touch with our IPSOS or our DTI Go Negosyo Centers. Okay? And then we also have the IP Depot, an online marketplace for registered IP products. Siyempre, meron din kaming free seminars for the general public. Ang tawag namin dito ay iLeap IP. We started this last year kasi nga nag-pandemic. So, June of last year, nagsimula tayo sa iLeap. Kasi internet-based na siya. Dati yung Leap IP program, free seminars din siya. Pero dahil nag-pandemic, nadagdagan ng I sa unahan for internet-based Leap IP, online. So magsisimula na ulit ang iLeap ngayong February. Just visit our website to know about the schedule. Usually, it runs from February to November. Okay? Free sessions yan. Just pre-register dyan sa iLeap portion ng ating website. Okay. Intellectual property protection is a race, be the first. Because we follow the first to file rule, no? So, sabi nga natin, filing for IP is voluntary, but we highly recommend that you file your IP para hindi kayo magaya. So, it is a race, be the first. Okay? Protection, IP protection is a race, be the first. If you have questions, then you may contact us with this number. So thank you very much. It has been our pleasure to share with you what IPOFIL is doing and how IPOFIL can assist you in protecting your intellectual property creations so that you can use these to your advantage and gain competitive edge. Again, good afternoon.